shall we begin? There's little left. We'll cover that, and then I think we'll open it up for questions from you. We'd like to hear your views, and probably if you have any doubts, we'll try to solve them. I wanted to talk a little on specific modern day areas and specific areas in terrorism which might be relevant, and one thing which we were talking was tech-based terrorism. So cyber attacks and use of technology in terrorism. This has become a reality, as I mentioned, and drone attacks have become a reality, as I mentioned. Our Air Force base in Jammu was attacked, and how it happened was there was a drone carrying a parcel of bomb, comes across the border and drops it on a strategic location, which was the Air Force base. So it is very difficult in terms for investigation as well as jurisdiction for that matter, to find a person who was behind it, who controlled the operation, who ran the drone, who was the mastermind, finding them, identifying them, investigating the offense, extraditing them. It's extremely difficult. There are challenges across with terrorism becoming a faceless form of terror. And our cyber attacks modern day, we imagine terrorists as people with a certain dress, with guns or ammunition, launching an attack against us. But today our modern day terrorists might be very difficult to distinguish. He might be an ordinary person and probably even younger than we imagine, because he might be a person who's tech savvy and probably could be a younger person. He might not even be wearing what we see in this image. He might be an ordinary person with a laptop sitting somewhere, may not be in enemy territory, maybe in a neutral area, launching an attack which causes significant damage to the country's interests. And what kind of attacks he would undertake are these. He would disrupt your networks. He would hack into your systems, delete data, compromise the system, hack into websites, prevent you from accessing what you should be able to access. He might access information that he should not know, and that is an act of cyber espionage. That is strategic information like defense locations, defense strategies, government policies, critical information about the country that should not be leaked to enemy countries and enemy institutions. That could be leaked out and making our country insecure in the sense that we are prone to attacks in that sense. He could also disrupt critical infrastructure systems. I would give a very simple example. For example, there could be a terrorist who hacks into your traffic signal server, flips the switch, and what should, on a highway, for example, he flips the switch and suddenly puts a red light. Whatever's going in speed will have to suddenly brake. What's coming behind would probably hit. There would be a mass pileup on a highway. You could also have what has to be running is stopping, what is running is, what should not be running is running. So then you might have mass traffic jams, mass accidents on highways and main roads as well. So you could do damage, which is physical damage also, by the use of technology. So today your terrorist might be a far more tech savvy person and very difficult to identify him and bring him over and to face the music in terms of adjudication. Where is this covered in law? You should know. So number one, let's look at IT Act 66F has a very specific offense of cyber terrorism. And what does it cover? Again, I break it down into two buckets. These are the three activities covered under 66F, that is denial of access to computer resource. And we've seen a recent set of attacks which have happened. The RBI, for example, aims, you have DDoS attacks being committed. That is, they access and prevent you from accessing what you should be able to access. So you are unable to access what is your server, what is your network, what is your resource, one. Second is he might access something that he should not know or should not be able to access. So that is one thing. Or he introduces a contaminant like a Trojan horse or a virus which deletes data which, and imagine from a judicial point if, for example, legacy files get deleted. It's a massive loss which cannot be replaced. They could cause damage to the institutions by this attack. These attacks any hacker will do. Coupled with the intent, it becomes a cyber terrorist activity. So this is the intent. So an attack of cyber attack coupled with the intent to strike against the country and its sovereignty becomes an act which is cyber terrorism. The outcome, I wanted you just to look at this because this was brought in 2000. At that point of time, the outcome that they imagined seemed to be very wide. That is, an attack, cyber attack targeting the country and its interests could cause any of this, so far as even contempt of court and defamation. So it's a very wide outcome that they imagine, quite broad. Other than that, let's look at BNS if we can imagine if it can cover cyber terrorist activities. So I would read out the lines that are in underlined. So it says, whoever does any attack, any act with the intent by now we have understood, targeting the state. Whoever does any act, clause A, by any other means, whatever nature. It could be a cyber attack, any other means, whatever nature, to cause or likely to cause loss or damage or destruction of property. Can we read property to be e-property? Possibly. So if he's causing damage, destruction or loss of e-property, that's an activity that gets covered. That second one is disruption of any supplies or services. Services essential to the life of the community in India or in a foreign country. So disruption of services becomes a outcome. Or the last clause, damage or destruction of any property used for defense or for governance. So if there is, and I would say property again, e-property. So by any means, that could be cyber means, which targets to destroy property or disrupt services or damage or destroy defense or governance properties, is an attack that is covered under 113. So to my mind, 113 also becomes applicable, and then again read with the extraterritoriality, you have jurisdiction to deal with any act that was committed beyond the territory of India targeting a computer resource in India. So in that sense, you can even prosecute a person who did not do this act in India. So that becomes a relevant consideration. Terror financing. Now, because this is not an offense under BNS, I am dealing with it separately, so you know where terror financing lies in the existing framework of law. And why is terror financing so important is because any act requires resources. I need resources to even purchase guns, for example. I need money, I need the economic wherewithal to commit an act. And how am I going to do it? By illegal activities. Because I'm committing a terrorist activity, I'm going to gain money by illegal activities. So I would raise funds, I would fund it by raising funds through any of these means, which would now today be an organized crime. So raising funds through extortion, drug trafficking, foreign funding, counterfeit currency. And extortion here, Sudesh Kedia's case becomes relevant because it says if there is a person who's extorted of money, and that money ultimately goes for terrorist activities, they are extorting money to commit terrorist activity because he's coerced into providing those funds, he is not liable. That is what Sudesh Kedia's judgment of 2021 gives us. But then terrorist funding is committed through these mechanisms. Where is it covered? Section 17 UAPA. This didn't get copied into BNS for reasons unknown. This has not been treated as an offense under BNS. What is terrorist funding? Funding for terrorist activities, the offense, the ingredients. I would just give you that. So it penalizes the raising, providing or collecting of funds, whether it's from a legitimate or illegitimate source. You raise funds for terrorist activities, whether in India you raise the source or you raise it in a foreign country, both of these activities will be covered. It also includes raising of funds which would be counterfeit money. So even if you use counterfeit money for funding of a terrorist act, that is also covered. Now here the point that is there, that is important is, anybody can raise funds, but if I provide or I raise that fund, knowing, my intent is absolutely important, my knowledge is important to make me liable for raising funds for terrorist act under section 17. I should have known at the time of providing, raising or collecting these funds, that these funds or even a part of it will go for terrorist acts. If I knew at the time of doing this activity, I am liable even if those funds do not get used. At the time of providing, for example, I am giving the money, I knew, I gave 100 rupees, I knew that 20 rupees of that 100 rupees will go for terrorist act, likely to go. My knowledge binds me even subsequently if that 20 rupees does not get used for terrorist activity. So my knowledge at the time of providing that fund makes me liable even if those funds don't get used. So actual use or not is irrelevant, but I should have known. So my intent is required, my knowledge is required. It also, as I mentioned, covers provision of funds through counterfeit Indian currency. So even if I provide fake funds, I can't say that, oh, I provided fake money, so that doesn't apply. I provided counterfeit money, I am bound by my knowledge of providing it for terrorist activity. That makes me liable. Section 40, as we already discussed, you raise funds for a terrorist organization, that also is a punishable offense. Not in BNS. So for now, we would have to depend on UAPA for these activities, and that might be a rationale for roping in UAPA in the trial if you add it as a separate charge. Organized crime. I wanted to just mention a bit on organized crime. Why I'm mentioning, as I mentioned earlier, there are state level legislations on organized crime which are linked with the objective of promoting insurgency. Organized crime under BNS does not have that promoting insurgency as a part of the term of the offense. It does not say that organized crime is done to promote insurgency. BNS deals with organized crime as a standalone offense. So you do activities for material benefit as a syndicate. It's an act which is punishable under section 111, organized crime. But in the grander conspiracy of terrorism, you will find organized crime being a part of the conspiracy. And why? Because I said, to do any act, I require resources, I need funds. And how am I going to raise these funds? Through the commission of an organized crime. I will traffic, for example, I might involve in human trafficking. I might raise funds through this illegal activity, raise that funds, that is illegal money because it's raised by illegal activity. I launder that money, so PMLA becomes relevant at that stage. I'm laundering that money. And then I finance a terror outfit or I finance a terrorist activity. So that becomes the chain. Terror funding again becomes the part of the link, ultimately accumulating into the commission of a terrorist act. So in the grander conspiracy, organized crime might also become one of the aspects that you will be dealing with when you deal with terrorist offenses. So in that sense, I wanted to just highlight on terrorism and its linkages with organized crime. The last point, last 2 points that I wanted to make, and I will stop after this. I wanted to just dwell on the jurisdiction in terms of investigation as well as trial with regard to terrorist offenses. So now this procedure applies, let me at the start itself say, it applies to UAPA because that's a scheduled offense, and it also applies to the offenses of waging war and endangering unity, integrity and sovereignty of India. These two offenses which are offenses against the state, also this procedure will apply by virtue of the notification of 16th July. So what is this procedure? Now simply put, NIA Act has a schedule behind it. It lists certain offenses which are recognized, which trigger the jurisdiction of the NIA Act. So in that, when the offense is committed and the FIR is lodged quoting those sections, now the police is under a responsibility to inform the state government that there is an FIR regarding the commission of a scheduled offense, that is a scheduled offense under NIA Act. Police informs the state government in turn has to inform the central government there is a scheduled offense for which an FIR is lodged. Now the central government has to take a call. They have to decide, and within a period of 15 days, they have to decide whether to call the entire investigation up to the NIA, which is a federal body for investigation, specialized investigation, or they let the state police continue with the investigation. This decision has to be taken in 15 days. Other than that, if the central government itself recognizes and takes cognizance of an offense, it suo moto can order the NIA to investigate. It will lodge the FIR and require the NIA police to start the investigation. So without the procedure before, the central government can suo moto also direct the NIA to commence investigation on a scheduled offense. Now, two scenarios come in. One, within 15 days, central government decides to order that the NIA take up the investigation. So now, at this point, it will direct either two things. One, NIA takes up the investigation and the state police has to assist. One. Second, it can require that the investigation is continued by the state police under the monitoring of the NIA. Two things can be done. Either directly the NIA takes up the investigation. Now, if it does not, then the state police continues with the investigation, right? Now what happens further is, once this is how the investigation happens. Once the jurisdiction of the NIA Act triggers, that is, it's a scheduled offense, the jurisdiction would be the NIA courts. There are two courts. One is the Section 11 courts, which are designated by the center, and there are Section 22 courts, which are designated by the state. So if the matter is investigated by the NIA court, which is as per the order of the central government, then the NIA court designated by the center will be the jurisdictional court which deals with it. If the investigation is done by the police at the state level, then the NIA court under 22 designated by the state will be the jurisdictional court. If there is no designated court, then the sessions court is the court that will take up the matter. At any point of time, this matter can be transferred to the NIA. There's one issue that I wanted to point out, and I would advise you to look at Nasir bin Yafai's judgment of 2022, which talks about operational transfer of the matter from the state police to the NIA. And this is in a circumstance where the matter is ordered by the central government to be investigated by the NIA. When does it effectively stand transferred to the NIA was a question that came up in this judgment. Now what happened in this scenario, this is a case from Maharashtra. There was an order that the matter had to be investigated by the NIA, and there was a bit of a time lag between the files being handed over to the NIA. While that period was going on, the state police continued with the investigation, and what followed next was framing of charges, filing of the charge sheet, framing of charges, and the sessions court continued with the trial. Here then the issue came that when there was an order of transfer, how could the state police continue with the investigation? The Supreme Court was very clear on this. They said at no point should investigation be stopped for an offense. The continuity of that investigation is paramount. For that, operational transfer of the files is important. It's not enough that the order is given that the investigation stands transferred to the NIA. The NIA must take the files and commence the investigation. Till that point of time, the state police is well within their right to continue the investigation and continue what is the requirement under criminal law. So for this point, I would advise you to look at Nasir bin Yafai's judgment of 2022. That would be a relevant factor. This would apply to, as I mentioned, to the offenses that are scheduled offenses minus terrorist act. In my opinion, right now, terrorist act, this procedure and the jurisdiction would not apply. That would continue under BNSS, and the jurisdictional court would be the sessions court, till a specific amendment or an order is passed mentioning that Terrorist Act 113 is a scheduled offense under UAPA NIA for that matter. Till that point of time, this procedure would not apply. My last bit of point that I wanted to make was, we started at the point at the beginning, distinguishing between acts of violence and offenses against national security. Where do you draw the line? It is easy to read any offense, any act of violence and say it endangers integrity, state, how. But the point is, do you have to, should you, in the intent of the legislature, read the intent of the legislature, do you rope in offenses against national security and national security laws into every act of violence is a question that we need to consider. So for that, I would take you to Ram Manohar Lohiya's judgment of the Supreme Court, 1966. Justice Hidayatullah gave a very beautiful description of how criminal law stands. He has given it in words. I just put it in a picture for just coherence sake. He has said our criminal law and criminal law offenses operate in three concentric circles. The outermost circle is very general. The innermost circle will be the most exclusive circle with limited application, exclusive application. So now, the outermost circle is offenses which affect law and order. Little more restricted would be offenses which affect public order. And when those two concentric circles cannot deal with it, the innermost circle gets triggered, that is the offenses against national security, which is offenses against the state. Terrorism law belongs to that extremely exclusive inner circle. And the point that the courts have made is you need to draw a distinction between these offenses, that is offenses affecting law and order, public order, national security, and limit the application of national security offenses to actual cases where the intent seems to be targeted at the state. And how would you identify it? By looking at the mens rea. So how to distinguish? Look at the mens rea. The mens rea is one, targeting the state, firstly. Secondly, it would not have a private, more personal, one-time objective. It would have a larger general purpose that they are targeting to do. They have an objective, as we talk, political objective. There would be a political objective driving this. The intent would be to target the state and the country and its people, and it would be using coercive intimidation as a technique. So the distinguishing elements are what you need to look at. Here again, then they have also drawn the point, the last point that I made here, they said, ideally, if an offense can be dealt with under the other laws, that is, it's an ordinary, can be dealt with under the laws which deal with ordinary crime, probably you do not need to deal with it under national security laws. So if it is beyond the capacity of existing criminal law and law enforcement agencies, ordinary procedure, then you might have to consider whether you need to trigger a national security law or a national security offense. Here, and a point that they've made, and one of these judgments, the Delhi High Court, is in light of the Delhi protests that happened in the last few years. And they said, please don't treat acts of protest and legitimate dissent as terrorist acts, unless the intent to target the state is discernible from the factual allegations. So they've said, please don't apply this blankly to acts of protest and, kind of sloganeering on the street. Here, this is the advice of the High Court. Again, this is a Delhi High Court view. They said, please avoid adding terrorism legislation because one, national security is a very exclusive area. The innermost circle has very limited application for very exclusive cases. The intention of the legislature is to apply it to a limited set of circumstances which the ordinary criminal law mechanism cannot handle. If that is the case, and if you apply it to generally to every offense, you are one, trivializing the law, and secondly, you're defeating the intention of the legislature. So they have advised, try to only deal with terrorism law where there is a threat to the nation, threat to the existence of the nation and the interest and the defense of the country. So apply it to those limited circumstances is the advice. Again, they've said don't casually apply it to things that can be dealt with under conventional offenses. And this is the advice of the Supreme Court. Lastly, they said please be cautious so that you don't adopt an approach which brings all acts of lawlessness into the fold of terrorism law. Limit it to only offenses, to activities that are targeting the country and the security of the state, only till that, and where the intent is to target the country, limited to that. And with that, I think I will stop. We have time for questions, which I think both of us would try to handle as far as possible. Thank you.
Thank you, Madam, for your valuable and elaborate deliberation. Now, let us begin reflective section. So I request all the participants to put questions to our Madam, and I myself will try to answer your questions. But please keep in mind, our Madam is coming down from the Bhopal to here, so let us take advantage of our Madam's presence here. So put questions, whatever you think, whatever you keep in mind about these new criminal laws regarding this topic first. So, please.
Sir, can you hold your mic closer? We can't hear you. Yes, sir. Better. Extortion. Okay.
Is it possible to include that extortion into the modus also? You have given in slide that some topics which are not including extortion word. So is it possible to include extortion also?
So you're trying to ask if modus, the modus of extorting money.
Yeah, no. Modus means there are four, five things which you have included in the modus, no?
Yes.
So, but extortion is not there. But
yes,
extortion become a very important point. Actually, there is amalgamation of organized crime and terrorist act. The terrorist as well as organized crime persons have joined hands together, and they are carrying out activities which are beneficial for them, like terrorist person is using the infrastructure of organized crime persons, gangsters, by using their men and arms ammunition to create terrorist activities, while gangsters are using their infrastructure abroad to move abroad and settle down abroad and running their activities from abroad, like this Lawrence Visnoy and other is this Bombia gang. The people are doing this type. I am investigating that case, so I wanted to know if this type of activities may be included in that category or not.
So to my mind, the factual scenario that you are mentioning seems to be more of an organized crime scenario. That is, extortion itself is an organized crime, where they are using it to gain an illegal, unlawful benefit. So that, to my mind, would be more an offense under 111, more than 113. I would say, primarily I would look at organized crime as the offense that governs a fact like this. That is, you are extorting money from various people, civilians, and using it for your own illegal means, right? So I would say this is more of an organized crime.
No, ma'am, I am saying something different. Actually, people have joint hand to carry out terrorist activities, including organized crime. See, they people are working together, like Khalistan Commando Force. People are carrying out terrorist activities or preparing for terrorist activities in sync with these gangsters.
Right.
So they are using their infrastructure, they are transferring the funds, they are carrying out the terrorist activities. So there is basically a new trend which has never come into the picture in India previously. But right now this thing is going on, like Gogamadi murder case, like 3-4 target killing in Punjab. So these activities has been carried out by terrorists sitting abroad in association with the gangsters operating in Punjab as well as Delhi and Haryana. Okay. So I am talking about those things.
I think I understood, sir. Two things that come to mind is, one is you're saying there is an extortion activity being committed. One, this funds is being raised illegally through extortion by a group of people. They ultimately use these funds for terrorist activities, amongst other things, including organized crime, right? They're committing organized crime also, they're committing terrorist activity. Am I right, sir? So two things would come into place. One is raising funds for terrorist act, section 17 UAPA, would be applicable to the person who's raising these funds for terrorist act. So section 17 UAP would apply. Second point, go to Sudesh Kedia's case, 2021, where they have said the person who's being extorted is not liable. When you are coerced into giving this money, you cannot have said to be willingly have provided funds. You cannot be penalized for providing funds for terrorist activity. So the person who is coerced by extortion would not be liable. But definitely the person who's raising these funds, doing this activity and doing organized crime, he would be liable under 17 UAPA, as well as if he's committing an organized crime which ultimately leads to terrorism, he could also be penalized under 111, that is organized crime. So 17 and 111 would be relevant provisions that you would need to look at, sir.
Thank you.
Yes.
What I was telling is that organized crime is more of economic in nature, to gain of the more of an economic benefit. That's why if you see section 111, organized crime, we have this sequence of offenses. It is not one offense. For example, kidnapping and ransoning. So it is again mix of offenses for the benefit of economic benefit. If we go to the section 113 or the section 15 of the UAP Act, the very first line it says that destruction of property or the sovereignty and integrity against the state. So it is more of a state, whereas organized crime, it is more of gaining illegal access or illegal benefit of the money. That's what we can, that is one of the key points that there. So now Rising of the funds and the extortion. Now, what is the basic difference? Rising of the funds, you have a consent or a tacit consent of the person who is giving the money. I may say that I may going for a separate Kalistan or something else, please give me the money. That person is motivated to give me the money and is this one. Whereas in the extortion, if you go to the IPC as well as in the BNS, extortion using the criminal force without the consent of the person to get the possession of the money or whatever it may be. So there we can find the difference. Ha. Terrorist, the ultimate aim is to terrorist case. Then we can, yes, UAPA.
So one point with regard to organized crime, it could be for a material benefit, which may include a financial benefit, but it is material largely is economic. So as I was mentioning, in the grander conspiracy, if you look at it, organized crime does become a chain in the commission of terrorist activities, one. Secondly, I would point, and this was one thing I wanted to deal with in another scenario, but I'll take you there anyway, and two things we can cover. Look at 32 of BNS. 32 of BNS says, and very simply I'll put it, just a sec. Acts to which a person is compelled by threats, because you mentioned he's forced to give money. Except murder and offences against the state punishable with death. Nothing is an offence which is done by a person who's compelled to do it by threats, which at the time of doing it reasonably cause the apprehension that instant death to the person will otherwise be the consequence. So if he's being coerced, then he doesn't become liable by virtue of 32, because if he's able to show that he was coerced by a fear of threat to his life, yes. And one more point with regard to organized crime, extortion is specifically, unlike the state legislation, extortion is specifically by name mentioned as an activity that falls within organized crime. So when it is linked with terrorism, definitely as a part of the conspiracy, you will deal with it as organized crime, but also if the other person who's raising these funds by extortion, he will also become liable. We can absolve the person who's being extorted by virtue of 32 and Sudesh Kedia, but the person would be liable either under, both under organized crime, 111, and 17 of UAPA. So with regard to organized crime, there is a state level legislation, sir. So, okay, so there is no state level legislation for Manipur, but there are about 7-8 states where there are organized crime state level legislations. Haryana, I'll have to check that. There is a, yes sir. So that's a new legislation coming. Broadly, all of them are on the same page. They are more or less similar to Maharashtra's law on organized crime. Yes, sir, Makoka. Probably not, so I don't think it has retrospective application. One thing with organized crime, I would say, since you have mentioned this, I'll take it a little further. Today there is a person, right now I don't think that you can have a retrospective application, but in organized crime there is an exception. For example, today there is a group that is committing organized crime, you want to charge a person. The provision allows you to look back 10 years for any, it says continuing unlawful activity, right? Continuing, they have said if you want to see continuity, you can look at existing FIRs for the past 10 years. Because otherwise, if you see 531 of BNSS and 348 of BNS, it says repeal and saving. It says, it draws a clear line of divide that from July 1st, you will apply BNS, things gone before FIRs will continue under the old law. Here, this allows you to read and consider previous FIRs under the old law for activities of the same nature done by the same person or the same syndicate. So past 10 years activities in a new incident happened post-July, you can definitely consider. So in that sense, you can have a bit of previous application. If he commits an activity post July 1st, then you might you will be able to consider things he's done before 1st July. In that case, you can, but otherwise, first he needs to commit an act post 1st July. This I wanted to take you to 32 with regard to, there was a query once, somebody raised it in a program from the state itself in CAPT. They had raised an issue of young people being taken, coerced, forced to join a terrorist organization, and terrorist organization, and are put through training. They are minors, and later they are entered into the membership rolls. So the question arises, when they are caught, are they liable or not? So number one, I wanted to just make a point, if he's a minor, his consent is irrelevant, because he cannot, as a minor, consent to anything. But the question arises, suppose he is at the age of 18, post 18, continues, maybe he's under duress, maybe he's under coercion. So then, when he does not break free from the organization after he turns major, is he liable when he's caught to be punished as a member? So here then 32 becomes relevant, because it says if he was under a threat to his life and that's why he continued to be a member, maybe you can consider that he's not liable. So for these kind of scenarios, 32 would be your answer. So if he's under a threat to his existence, to his life, threat to life, then these kind of cases where they're coerced, you can draw an exception. That's just the point I wanted to make. I had promised them that I will research it and give them an answer, so I thought now would be a great time to answer that. Sir. He's saying that he was engaged as a lawyer. So whether he is liable for the activities of terrorists. So to my mind, this seems to be a completely different scenario. That is, you are a professional, an advocate for that scenario, and there is an organization which is a terrorist organization. Am I right? Correct so far? Or an unlawful association?
Yes, I know that. That very accused is a member for that allegation of being a member of unlawful association.
He is a member.
He is a member. Allegation. The case is to be fight in the court. In the meanwhile, who engaged me? He is in the custody. That very accused is in the custody, and I have been engaged by another high-profile member of that very organization.
Okay.
He came to me.
Him.
I have been engaged by him on behalf of the accused in the custody. Then, whether it shall be interpreted that I have been promoting the activities of that very organization or not.
No, sir,
we are
to
in
my
the
mind,
profession
no.
only, but this very provision of 132 of this BSA does not provide these things, I think.
To my mind, sir, no, I don't think you are liable for doing a professional duty.
Yes,
I don't
professional
think so.
duty, but my confidential communication may be leaked because of the surveillance, adequate surveillance of the security around my chamber.
Right.
We have confidential communication with our clients, but it has been leaked.
It has been leaked by intercepted communication.
And kept by the securities. Then in that case, what will happen to me?
Sir, I would say you are not liable because you're doing your professional duty. Very honestly, that's not an activity that is targeting the state.
But the fees paid to me is maybe somewhere from the other source.
He's brought illegal money and he's paying you.
I don't know that also, but
Possibly.
the allegation comes to me.
That's a problem, sir. I do. But you did not collect those funds for terrorist
Whether we are
activities. So
fully
you're not
protected or
liable
not
for
in my
that.
profession is this is my question.
Yes, sir. You are not collecting funds for terrorist activities, first
Yes,
of all.
I am not collecting, I am taking the money which has been collected from the illegal field.
Sir, to my mind, no. You're doing what is your professional duty, and
There
that
may be
does not become
confrontation
a...
between the police and our profession in that case. I want to clear this.
That becomes a challenge in practical terms because they will be like, how are you representing a terrorist is a concern, yes. But legally, I don't think you are liable for doing what is your professional duty, in simple terms, sir.
Partly this is provided in 132 of this BSA.
So you have something to add, sir.
Yeah. But whether completely protected or not, this is a very challenging question in
I
our
understand,
state.
sir. Sir has something to say to that.
See, here you are following just only the professional ethics. For the lawyers, there is a professional ethics. For example, a murderer comes, for example, a UAPA member comes or a terrorist comes and you have taken up the case. And there is a professional confidentiality also. So he might have told that I am the murderer, I am the one who have made the terrorist this one. But your professional ethics allows you to take the case and still fight the case that he is not a murderer, he is not this one. Now coming back to the question that you have received the funds from him. The ultimate mens rea for you is that not to put it into any terrorist organization, but as a professional fees you are getting, this is the one thing. Another point is that how do you came to know that whether he is funding from the terrorist organization or this one? This is another question that is coming especially in the recent cyber crimes. So there is a portal called National Cyber Crime Portal, that is 1930. Earlier it was called as National Cyber Crime Portal for the Protection of Women and Children against cyber crimes. Now it is redesigned as National Cyber Crime Portal against the cyber crimes. Here what happens, for example, I am the victim and somebody A has frauded me 1 lakh rupees. Now immediately when I go to this www.cybercrime.gov.in or 1930 when I lodge the complaint, 1 lakh that has been frauded by A automatically will get freezed. Now what A will do, A will distribute 10,000 to another 10 persons, B, C, D. For example, B is a restaurant owner. A gone to the restaurant and paid restaurant fee and all those things as 10,000 rupees. Now what this cybercrime portal will do, up to the 10,000 rupees for the second layer, it will get freezed. Now B is asking a question, how can I know that the money paid to me as a bona fide fee or a bona fide restaurant bill of 10,000 rupees by A is a means of fraud? Isn't it? This is the question that the B, C, D, E are all asking in the National Cybercrime Portal. Yes, this is a major charge. But B will not be frauded or B will not be treated as a crime or anything else. Only thing is that their apprehension is there and the National Cybercrime Portal is thinking on these things. In any way, you will not be held responsible for getting the money, this one. And in the same way, B, C, D in the cybercrime case also, they will not be lead to this one. But yes, when it becomes fraud, now there are some cryptocurrency agencies like WazirX. Sometime back WazirX was in the news because WazirX and Angel and these did not follow the proper KYC rules. Now what they have done is that every cryptocurrency agency which is investing the money has to deal exactly with the KYC. That means to say that I am the person, I am going to WazirX to raise a virtual account in my this one to invest in cryptocurrency. Now it is the duty of the WazirX or the whatever be the platform to see whether the funds that I am parking there as an investment of cryptocurrency is a fraud money or is from illegal means. That is the thing that the new government rules have been come. So just for the information I am telling. Thank you.
I also would like to add,
My question further,
I'd like to add one question, this thing. See, if I'm a member of a band organization, they do have a right. They do have a right in a sense that they are not punished beyond what they deserve to be punished. And as an advocate, it is your duty to defend that, yes, he may be punished in such and such session, but in such and such a section is not applicable as per his acts done or as per being a member of the organization. So for defending an accused or any member of the Ben organization, any advocates have nothing to fear, because as a profession, it is the duty of the advocate to bring justice, to assist in bringing justice. So there's nothing to fear. Supposing if I buy something grocery and give 2,000 not, and that person who have kept terror fund, with that change, he returned back the money to me. That doesn't mean that I'll be charged because I got the money changed from terror fund, this thing. So there's whatever fee that you receive doesn't matter, whether, because that is the fee which you charge. Whether that is from a terror fund or from a clean or white money doesn't matter. That is a fee which you are supposed to charge. If you want to go pro bono, that's different matter. But that fee have no authority have the question. I mean, as Madam also rightly said, that fee which you receive are not going to further fund terrorist activities, but to support your family. So I think there is nothing much to fear for that.
But the still apprehension is there, because the one who engaged me indirectly on behalf of the person in the custody, he may be someone who has been proclaimed offender also, but I have no knowledge about him. In that case,
So
proclaimed
one thing,
offender.
just adding to the point sir said, because you are saying you are representing somebody who is a proclaimed offender, for this act,
No, that is not the question. That very accused
sir.
is in the police custody or judicial
Somebody
custody.
else who's
Then in the meanwhile,
member.
I have been engaged indirectly by another activist
Member.
or high-profile member of that very
Yes,
organization. Then he may be a proclaimed offender earlier or not, but he engaged me indirectly. In that case,
Right,
I am
sir.
liable for that offense.
to the point what sir was making, I'm just adding, he also has a right to a fair trial, presumption of innocence. So he may have committed offenses in the past, but can we convict him right now at the time? Doesn't he not have a right to a fair trial to be represented by a lawyer of his choice? If he chooses you, aren't you also duty bound to represent him? So in that sense, the presumption of innocence kicks in, at least for this part of the, he may have done things in the past, his members are roping you in to represent him. You are well within your professional duty to represent him. He is entitled to a fair trial. Even Kasab was given a fair trial. So in that sense, you are not violating any law. You are not supporting a terrorist organization or promoting a terrorist for that matter. You are doing what is your professional duty, and you are giving him a fair chance before the court. So within that, I would say you are absolutely entitled to do that, and you should rest assured you're not committing any offense as such. You're not a terrorist for
I'm
yourself.
not committing any offense.
Absolutely,
but
sir.
Something please. There is no nexus in between the receiving of
Yes.
that money and talking with the highly profound members. If he is not involved in the terrorist activities of that particular organization, that's why there is no nexus in between that particular organization and the receiving and the talking with that person. That's why there is no nexus. That's why he is not liable for that.
Absolutely, sir. And again, the point, I think that I've done my job well, if you're saying this. That is because ultimately terrorism offenses are mens rea emphasis-based offenses. Intent is crucial. So that intent has to be manifested to show that you had an intent to target the state. If you're representing him, that intent is missing. So mens rea is absolutely crucial if you want to bring in a terrorism offense against anybody, for you for that matter.
Yeah, but still
you do not have that intent, sir.
security
So,
surveillance
sir,
is
it's very
there
well
in my
put it,
chamber.
sir.
Another thing, that is another thing, but in factual, there is no liability for you because there is no nexus in between the terrorist act and terrorist organization and taking the fees and communicating with that highly profile person.
Absolutely, sir. True.
Thank you.
Very good afternoon. Very good afternoon.
Sir.
This is Syed Abdul Samad, SP Special Crime and Departmental Cases. Well, we are very thankful for your this session on terror, because I would like to highlight few issues and even technical issues and queries which we might be expecting. This terror offenses, right now, as of now, the state, we are very much familiar with UAPA. We are familiar in such a way that, that our state is having the maximum number of UAPA cases after JNK.
Okay.
And the conviction rate is also very low. As it has been already highlighted in the new laws, the SP has to decide whether to book under BNS or UAPA. Now, here comes the situation, as we have already experienced. An incident of IED explosion and ambush took place. We have witnessed innumerable cases. At that point of time, the SP will decide whether to book under, right now, as of now, as a practice, if it has led to explosions, explosive activities, then we add Explosive Act and other relevant sections of IPC as of until now. And if we know that such and such organization has already, they have carried out this attack, but as a practice, now there comes a situation, the SP has decided we will book under BNS. But in due course of time, XYZ organization has claimed the responsibility through media. Now the question arises, the ones which we have booked under BNS, what happened, what has been the practice is that we have booked under relevant sections of law at that point of time. But at a later stage, when such an organization has claimed the responsibility, we add that UAPS sections.
Right.
Does this provision still exist? This is the first question. This is my first question.
Question is asking is if later they are in the course of the investigation, they are adding in UAP. So can they do that? They can bring in the course of the investigation if certain other facts are revealed, they can continue investigation under UAP. They have lodged it under BNS and later they are saying can we add in UAP when investigation is continuing. I think so, sir, if you want. So two things would come out. What we are seeing is, yes, you can in the course of the investigation, you could file a charge sheet, you could file multiple. But the point is, if you want to, you can, if the materials as you disclose, that are disclosed during investigation, if you feel that UAP further needs to be brought in, yes, you can, but two things will come out of that. One is the moment you have brought in UAPA into the matter, then maybe the jurisdiction of the NIA kicks in. So then maybe that procedure that we were discussing earlier, having to report it to the government for a call whether the NIA takes up, that might become what gets triggered after that. So right now nothing stops you from examining the materials in the course of investigation and seeing if UAPA becomes a relevant statute to rope in during the course of investigation. I think nothing stops you from doing that, but consequences will change after that.
Fine, thank you. Next question, my second question is that it has been highlighted that SP has to decide whether it should be booked under BNS or UAPA.
Yeah.
But it is not clearly mentioned who is going to register the FIR. The SP has to decide, of course, it is fine, but who is going to register the FIR? As of now, the OC or SHO registers FIR.
As per NIA Act, it says the police officer in charge of the station would be the one registering the FIR. But then, if it is, he will have to act on the decision of the SP. So I think if you read NIA, that gives you the answer who's the person registering the FIR.
Is there any format for the SP to decide?
Currently, no. Format? In fact, I would say there's one step further. Format to decide, also the question is, it says shall decide. But does it require him to record reasons for deciding? It's still vague. It's up to you. Right now, the law does not say shall decide with reasons. He shall decide. But whether he has to record those reasons for lodging in either of the statutes, that also itself, the law is not clear right now. Maybe in the course of interpretation, when these matters come before the courts, they will give you a requirement of what needs to be provided when you decide this when you make this call. So whether the reasons have to be recorded in writing, right now the law doesn't require you to do that.
Good afternoon. Section 239 clause 5 also already
Where?
talk about the, madam.
Yes, sir.
Section 239 clause 5 of BNS have
Of
already
which law?
talked. At the time of investigation, it may apply BNS. But in the course of investigation, if some findings are found new in the course of investigation, it relates to unlawful organization. At the time of submission of his charge sheet, he may change it. Is this written in the 239 clause 5 of the BNSS?
BNSS, 39 clause 5. Let's have a look.
The deliberations of your speech, I
Yes,
have
sir.
already noted down that.
39 clause, 39 of BN. No, I'm looking.
239
239.
and 239.
That is addition of charges.
That is there. The IO of the case or the
That
SP
is-
concerned has the right to choose the option and depend upon the findings of the investigation.
239 is with regard to framing.
Yeah, that is the
additional charges.
submission of charge sheet.
His question was at the stage of investigation if they.
No, at the time of investigation, any BSN may be booked at the time of lodging FIR. But in the course of investigation, at the time of submission of charge, they have the option to submit in accordance with the BNSS or UAP Act.
Okay.
That is
The
there.
question sir was putting was a little one step earlier, that is, they've lodged the FIR under 113 BNS, and in the course of investigation, they feel UAPA needs to come in. Are they bound by the section in the FIR or can they add things later? That's what was the question that sir was putting. So that way, I think, to my mind, nothing stops you from seeing the material and directing the course of investigation. Till the point you file the final charge sheet, you're quite well within your right to explore what all offences are made out. So that would
Right.
be.
What I meant is that just after a few days of the incident, few organizations, they do claim that they have committed such type of act.
They
So in-
claim credit for the
yeah, claim the
act.
responsibility. That was the case.
Yes.
And secondly, ma'am.
Sir, just a question, just to understand how this is operating. You are saying that there is an activity which is done, terrorist act per se. Till the point nobody claims credit for it, it is going under 113. The moment somebody claims responsibility, UAPA comes in. Is that how it is operating, sir?
Right.
Okay.
UAPA or say, as of now, such type of activities we used to book under UAPA, or if UAPA, that too if they come under the schedule list. If they don't come under the schedule list, then we usually book under 400, earlier 400 IPC. So that has been the norm up till now.
Right, sir. Thank you.
And second, my another question is that the IO, investigating officer, is not being mentioned in the BNS. Under UAPA, not below the rank of DYSP, but as far as the NIA, an inspector rank officer has the authority to investigate the case. So what about, what is the case in this BNS?
It's an offense against human body. So whatever the investigatory powers that are there for an offense against human body, the same would apply. So the normal procedure would apply, sir.
Yeah.
There is no special.
Yeah, in the BNS, it is the, depend upon the nature and gravity of the offense. The SP can entrust the DYSP to take up the investigation. That sentence is specifically there in the BNS. So when the SP decides whether it is an unlawful assemblies or whatever it may be the case, 113 or section 15 of the UAP Act, SP has all the powers to entrust a DYSP this case. Because earlier Dowry Prohibition Act 498A and all those things were investigated by DSP. For example, in NIV it is the inspector, which is this one. But in these cases, depend upon the nature and gravity of the offense, the SP can decide. Yes.
Fine, thank you,
But
sir.
with regard to scheduled offences, which would be waging war and endangering sovereignty, those two offences in BNS specifically and UAPA, the officer as per the NIA jurisdiction would be the right one.
Fine.
Only for terrorist act, it would be what sir is saying, it would be that officer.
Good afternoon, ma'am.
Where are you? Yes, ma'am. Please.
I'm Sundarwala, SGPO. continuing from what Sir has asked, I just wanted a small clarification. If a crime is committed by a member of scheduled unlawful organization, will it automatically fall under UAP Act, or how do we attract Terrorist Act? Where do we draw the line?
So you're saying there's an organization, he's a member of an organization listed in the
Scheduled
first schedule.
unlawful organization that
terrorist
comes under
organization.
UAP, yes ma'am.
Terrorist organization. Okay, he's a member and he's committed an act.
So yeah, he has committed an act, so will it fall under, automatically comes under UAP Act, or like when do we attract the Terrorist Act, like where do we draw the line?
See, for the commission of the Terrorist Act, I think you would go under either 113 or 15 of UAPA. Because as such, if you look with regard to terrorist organization, only 3 offences are there: membership, support and fundraising. But for the commission of a terrorist act, you would have to go back to the offence of terrorist act, which is either section 15 UAPA and the additional sections along, or you would go under 113. So for commission of the act, membership aside, commission of the act, you would have to actually look at terrorist act as the offence. So there you would have to either 113 or, depending on what the SP decides, 113 or UAPA section 15 to 21.
What I'm confused here is, ma'am, the act is, let's say, the Terrorist Act, but it is committed by a scheduled unlawful organization. So which one to come, like first, UAP Act or Terrorist Act, or like when SP decides?
It's a terrorist organization, it's committed a terrorist act. The
What will come?
The factum is the organization is committing a terrorist act. It's banned, it cannot operate, that is a different aspect. But the commission of the terrorist act itself is a standalone offense. So the fact is that it is banned, it complicates things further for them, because you are a terrorist organization which is banned, but you committed a terrorist act. So for the offense, you will specifically look at only 113 and section 15 to 21 for the offense of committing the terrorist act. Right? So I would say first look at the offense that is committed, terrorist act, then add on things would be membership and etc. of a terrorist organization. The existence itself is illegal is one thing, but they have committed a terrorist act, that itself has to be penalized. So that would be 113 or section 15. So SP takes a call, depending, there is no rationale why they should opt for either or right now. Because you are saying because it's a terrorist organization already under UAPA, shouldn't you bring in UAPA offenses there, right? Or why should you go for 113 when it's already a terrorist organization under UAPA? That would be a decision for the SP to take. The SP might weigh these factors saying, it's a terrorist organization, committed a terrorist act, we need to bring in UAPA because that might deal more comprehensively with the entire matter in hand. That would be but for a SP to decide.
So, ma'am,
the law does not provide that.
What I'm confused here, let's say, ma'am is saying, even in the book is also saying that it is the SP who shall decide, but what, I just want to know what is the factor to decide?
Right now, the law does not provide any factor whatsoever to
so it is the
control the
discretion.
decision. So this might be the rationale that the SP weighs in his mind. He may or may not record this, but this might be the factors that weigh in his mind. 2-3 things might weigh in his mind. One is, does UAPA cover the entire offense, the nature of the activity, the organization, what has been done, more comprehensively than 113? That might be the factor. He says, okay, let's go under UAPA.
Yes.
That might be a rationale, but the law does not require him to consider that rationale, one. Secondly, he does not have to record these reasons, so we may never know if that was the rationale that was in his mind. So ultimately, the law does not circumscribe the decision of the SP. The SP has to take a call, depending on factors, even investigation for that matter. It might be far more suitable to investigate the matter under BNSS, because if we opt for 113, BNSS kicks in. So that might be also rational that they would want to investigate it under BNSS, or they might want the stricter provisions of remand and bail under UAPA. These might all be rationales which weigh. So, but these rationales are not prescribed under law for the SP to take a call. Right now, the law does not tell the SP how to do this decision. The SP will weigh all these factors and ultimately come to a call that we will ultimately see as the this jurisprudence evolves, what were the factors that came into mind when they made this call of picking either BNS or picking UAPA? But the law right now does not tell the SP how to make this decision.
Good afternoon, ma'am.
Good afternoon, ma'am.
1 minute, can't see.
1 minute.
Ma'am.
1 minute.
1 minute. The sir had said.
I will add something to her question. Suppose an unlawful organization which are declared banned under UAPAC Schedule first schedule, if they committed any act, any terrorist act, my advice is to the police personnel to register FR under the UAPA Act, because it was committed by the unlawful organization who are declared unlawful. So for any organization who are not declared unlawful organization, some organizations, if they committed any terrorist act, this is to decide by the SP. By the SP, suppose in the earlier time, police personnel registered the case under Section 400 of the IPC for any other crime committed by the gangs who are not declared unlawful. So now, those offences can become under Section 113 of the BNSS. For the crime committed by the unlawful organization, declared as unlawful organization, is better to register under UAPA. This gap, this distinction is only there. So SP has to decide. And another that I will add also to the question. Suppose a case is registered under Section 113. Then after that, during the investigation, some material is available which attracted UAPA. Then when the SP was decided, it should be registered under the Section 113 BNS. Then SP has to decide again. The IO has to report to the SP during the investigation, such materials are available which attracted UAPA. So he has to report to the SP, then SP again to review his order, first order. Then you can change to the UAP, then the procedures of the investigation for UAP will continue. Because handing over to the NIA or something, you have to change your investigation procedure. This is the thing. So we can, you can ask a question. Who are
Sir,
raise your hand.
may I interrupt?
Oh.
Sir, as you have stated, my question relates to Schedule 1. So if an organization is listed as a terrorist organization under Schedule 1 of the UAPA, but the Schedule 1 does not specify its formation and manifestation. Like there are some organizations I would not like to mention, however, can this organization still be legally considered a terrorist organization? Like there are some formation and manifestation, however, it does not mention in the UAPA, in the Schedule 1. So does the lack of such details invalidate its designation under the UAPA?
It's not specified by name in Schedule 1.
It does, it does specify the name, however, it does not mention its formation and manifestation. Like just say there is an organization, a terrorist organization, but there are some formation and manifestation. Like
it might have wings or branches or something.
Yes.
Are you trying to say that?
Yes. So
okay.
Does the lack of such details invalidate its designation under the UAPA?
So
that's my question.
If it is not mentioned by name in the first schedule, no. By specific criteria, by specific notification, a specific organization is declared a terrorist organization. There might be other organizations linked to it also which are not declared. No. It has to be mentioned by name in the schedule, only then can we penalize it to be a terrorist organization. So there might be manifestations, as you're saying, there are sister organizations or brother organizations which are not mentioned in the schedule. It does not apply to those organizations. Only the ones named in the official gazette, which are now included in the first schedule, only those it will apply to.
Okay, ma'am. Thank you.
Good afternoon, ma'am. Here it is. Sir, here, this side, ma'am. Your right side, ma'am. Yes, here.
Okay, I was expecting a question from her. She had something to ask. Yeah.
Okay. This is Saran Kumari. I would like to know from you that how do you define ethnic violence? And if it is organized by some group of people, then whether it will comes under the term terrorism. And if it comes under the terms terrorism, then whether it can be considered as waging war against the state under section 147 of BNS. Shall I repeat, ma'am?
No, I got the point. You're saying that they are committing ethnic violence.
Yeah.
Right?
How do you define ethnic violence? My first question. And if it is organized by a group of people, then whether it will comes under the term terrorism. And if it comes under the term terrorism, whether it will be under the Terrorist Act, which will comes under waging wars against the states under section 147 of BNS.
It would, depending on the factual scenario. Broadly saying, first coming to the point of ethnic violence. Very simply put, I won't give a very elaborate description of what I think. If it is a violence which is based on a rationale of any ethnical rationale for that matter, that is one ethnic community against another ethnic community, certain points like that, that would be what would be called a violence that is driven by ethnic reasons. So maybe that's what I would say would be ethnic violence. Coming to the point of whether this would be an act of, say, waging war. Now, if you look back to what we were discussing earlier, often these things are the intent behind an act of waging war. If you look back at when I gave you the intent part of waging war as per jurisprudence developed, it said waging war can be an activity driven to cause communal tensions in society as well as public order, disturbing law and order, peace and tranquility in the society. That would be, now you're trying to create a situation where there is unrest and public order problems in the country. That would be something that is an act of waging war. And then going to that judgment that I gave you in the last, which said internal disturbance, whether that is an act of waging war. The dominant intent behind it is to create a state where there is public unrest, you're basically causing a situation where the entire state mechanism, the prevailing peace and tranquility of the state is being put to peril. Yes. You're disturbing that. That would be an act of waging war. So, but it depends on facts to facts. You need to look at each fact, whether the driving intention behind that was to create such a state of law and order problems in the country to kind of destabilize the state in that sense. That would be something that I would say, if it is an ethnic violence, that would be something factually that would become a matter which is waging war.
So whether it can becomes under the term terrorism again?
It can be.
It can be. Thank you.
Or else sometimes it may comes under the definition of 103(2) also, mob lynching, and 117(4) also. Now, if you see the definition of the mob lynching, it says language, sex, community, and reasons to believe by those persons also. It is quite vague. So I feel that there is a person, and my community and his community are this one. So there is a word community also, and reasons to be believed by that mob. The only thing is that 5 or more persons are involved in that mob and they killed another person. So the specific word mob lynching is not there. So in these cases also sometimes it may be ethnicity but comes under the definition of the mob lynching 103(2) if the person dies, or if the person does not die but he get into a grievous act, then section 117(4) of the BNS will be attracted, just as an add-on.
Good afternoon, ma'am. I am Momota Thaunaujam. I am very grateful to witness your valuable session. And I want to discuss a matter there has been many cases recently where an arrest arising out of the Nakabandi, like a phrase seeking and checking, are being booked under the section 17 and 20 of UAPA Act. Then there is a delay of release on the accused from the custody on the ground of the seeking sanctions or further investigation. By that time, the freedom of the accused is restricted and restrained. It mentions essentiality to be liable for an offense, should not necessitate the state to prove its force.
Very simply, if it's a UAPA offense, remand is far more stricter, bail is also far more stricter. That is the interest of the state is paramount. So yes, if he is kept within the reasonable period of remand that is allowable, it would be a fair exercise of the investigative powers, that is they're keeping him in jail while the investigation is pending. The remand period is extended. So if it does not violate that remand period, so far so it's a fair exercise of power. So bail he cannot get as a matter of right. It would only be in cases where he is entitled for default bail. That is, he's kept longer than the period of remand and where the trial isn't commencing. At that point of time, yes, the courts have held that yes, the statutory bail cannot be held to be an unlimited exercise of keeping him behind bars, but ultimately he will be entitled for default bail after this period is gone. So till that point of time, yes, he can be kept behind bars. So bail is stricter.
But ma'am, the accused person has been met his arrest arising out of the frisking and checking on the allegation of the suspect.
But he's charged under UAPA.
Yeah, UAPA under the section 17. They are booked on the Nakabandi, like frisking and checking, and booked under the section 17 and 20 of the UAPA. But the SP sir also told that a conviction rate is very low, those who book under the UAPA. But till the time of the clear, should the bail granted or not, in your opinion, what the advocate will do in this period to save the freedom of liberty of the accused persons?
I would say for all stakeholders, including the advocate, follow the letter of the law. The remand, you can keep him up till the period of remand. Bail has to be granted if you're going beyond a reasonable period of time. Till that point of time, follow the letter of the law, follow what is required under 43D. That is where he can be entitled to bail. Look at that, and I think a fair exercise of those powers is what is in the interest of justice.
Okay. So, is it required a strict mens rea to essentiality to be a liable of an offence?
I'm sorry, I didn't get you.
It is required a strict mens rea for those who arrest on the Nakabandi and book under the section 17 and 20 is an essentiality as per according your slide. Mens rea is essentiality.
Essential, yeah.
Yeah, and it is like, should know the law necessitated to state the proof each offence, or how can we proceed for the further?
See, up till this stage, it's all on a prima facie evaluation of the materials before you. So at that point of time, if the materials disclose that he is liable, he seems to be complicit in the offence that is involved, 17 for that matter. Till that point of time, yes, the provisions that follow will kick in. So yes, bail is not a matter of right as such under UAPA. It is a far more stricter provision. But that letter of law will apply the moment the section is invoked. Okay. So that is the reality of the statute. We will have to be, but please remember, if you are applying it to very limited cases, you are not going to have everybody being charged under this, if you apply it fairly. So this kind of a stricter provision of incarceration will not apply to every case. This will only apply to offences against national security. But yes, it is strict.
Okay, thank you, ma'am.
Good afternoon, ma'am.
Yes, sir. Yes. There was one sir up there who had a question. Yes, sir.
My name is Thingom Susni Kumar Singh. My question is, A has love affairs with the lady B, unknowingly that B is a sister of one leader of UG listed in the first schedule of UAP Act. B called A for dropping to her house. A go there and pick up B. On the way, they met frisking and checking conducted by CDO under the supervision of the SP of their jurisdiction. From the possession of B and her lady's bag, seized one live round ammunition, 4 letterhead of the UG and some case at around 9 p.m. Under section 42 clause 5 of BNSS says that some except in exceptional circumstances no woman shall be arrested after sunset and before sunrise, and where such exceptional circumstances exist, the woman police officer shall, by making a written report, obtain the prior permission of the magistrate of the first class within whose local jurisdiction the offense is committed or the arrest is to be made. Then B has handed over to her parents or her relatives. And police also did not take prior permission of the magistrate first class. By that time, it may be there are unavoidable circumstances. Here, my question is that A shall liable under unlawful UAPA Act as he did not know the law, or there is no law any means to arrest the lady B for smooth investigation, and shall be free from that terrorist act.
Okay. He's saying that the girl was with him. She took him, went with him. He was caught. But
Your question is very low, so
so you'll have to use your
please
mind.
bring your this written.
Actually,
Moderator, the Manipur da amu yahjarake A sina B kauba nupi amakak love affairs lejare. Unknowingly ma B se ngasagi akogi one leader UG amagi masan ne haibasidi A sina khanghou dem. Adubu ngasagi B sina
nangi ama kanodo mi ama the UAP the haido kano raba organized crime ke kano to mi raba kambu raba.
Oh, ngasagi listed in the first schedule of UAPA Act ki makada leba amakaki masanupi oidune ba B se. Ado ngasagi B se ma di aduni haibase A sina di khangja hokdreba. Adubu mabani love affairs di leithoreba. B na ngasagi A se da ai gari phangre pharak tare aduna ai yumbau da di drop to bi on man harak badagi A sina mamanabagi gari ma waira kana B se lokhalure adu mai mayum da thinba lakpa kan sidai da ngasagi on the way da ngasagi commando na frisking checking to wa ma thengnare under the supervision of SP from their mokogi jurisdiction dugi SP ma thengnare thengna kana ngasagi makoina check to ba kan sidai da ngasagi nupi sigi magi position dagi magi ladies back dagi ngasagi akoi one live round immunization ma sistore 4 letter head moi ngasagi mabung dugi UG dugi phange some case kharasu paisa kharasu phange aduga ngasagi hujiki law da akogi section 45 clause 4 CRPC aduga hujiki new law gi section 42 clause 5 BNS da di before sunrise and sunset ta nupi di phaba yadre hare karigumba phaba ta phaga dabne hargadi akogi prior permission ama akoi magistrate first class tagi logadobne na hare adubu nungdangi matam oyunina madu unavoidable circumstances da police tuna ngasagi madugi prior permission do logdaba ni khangde adu baina logidre aduga hariba nupi B se ngasagi maki mama mapa natragana magi my relatives da handed over to thokre nungdang sida ado aina huji hangjaningi bo question sidi A na B lokhat pa chalu base ngasai UAP gi law se ma khangda baduna maram orakanda ma liable oigaduribra natragana B C smooth investigation gi damakta mahak se arrest tawba darkar oidabra natragana ngasai gi B se haiba terrorist act dagi free oiba oigaduribra
A to the far bro police na
A to the faraga madi judicial remand like the yora.
sir, I kumage sikse matam mange ba. Go. I think we are off shooting our lunch time again. The tea was cold before, no, so it have to be reheated again. Anyway, Hajiki Miyamasi a terrorist. Somehow he make a fake identity and he was traveling by Indigo flight to Delhi. carrying such incriminating documents like demand letter and all. Can the pilot be arrested or can be he booked? There's the same question here. Not at all related. He's not a member. He have no knowledge, no intention. He may be a witness, but he cannot be made an accused. Regarding that ethnic violence, Madam, that, yeah. See, ethnic violence committed by a banned terrorist organization, which is in the Schedule 1, yes, it's a terrorist act. But ethnic violence committed by some individual, it cannot be a terrorist act, but he can be put under BNS. That's a different matter, but it will never come in under UAPA Act. I think we have to break for lunch. And whatever other questions now we can have during lunchtime.
May I have the last question? May I have one last question?
I feel bad that he had a question first.
Hello? I just...
Please change your microphone.
Use the other mic if this one is not working.
Hello?
Yeah, that's better.
Okay, I am Paikomba LADC, Chief LADC of Thogwal. I just want one clarification from Sir Manoj. As Sir Manoj has stated that if a case is registered on the 113 BNS and later on the IO added provisions, sections from UAP Act. In that case, Sir has stated that the IO has to report the matter to the SP and the SP has to review his earlier order. But sir, instead of that, can the IO report the matter to the OC? And can the OC be reported the matter to the concerned magistrate instead of reporting the matter to the SP directly for reviewing his earlier order? Can this be? Thank you, sir.
No, there is explanation in the section 113. SP has to decide in which section UAPA or section 113 of BNSA. SP has to decide. So OC cannot decide. So if the IO during the investigation find having prima of material of attracting UAPA, yes, he can report to the OC. Then OC is to be reached to the SP. SP has to decide. That's why SP has to decide. It can become up to from OC. This is IO is SI or SI. He has to report to the OC. Then OC to report to the SP. Lastly, SP has to decide. First, he has to take decision. Then it should be under the under the section 113 of the BNSS. If the matter comes up like that, the OC or IO has to bring the matter to the notice of the SP. Then SP has to decide again whether it should be under the UAP Act, under the 113 again. He has to decide.
Just to add to one point, to what Sir was saying, when you are lodging the FIR, it's right at the beginning of the matter. Whatever the materials disclosed at that point of time, the SP will take a call, whether 113 or UAPA. But then in the course of the investigation, more materials definitely will come forward. If things disclose that UAPA needs to be added in, I don't think it's a letter that, you can't look any further than 113 if it is lodged under 113. You can always, based on the material in the course of the investigation, look at the other offences that are being made out, what materials disclose, whether you need to rope in UAPA. So ultimately, till your final charge sheet is filed, I think you can definitely explore both the statutes and see what your investigation, where it takes you. So that way I would say it's not a hard and fast rule that once 113, nothing more. So even the investigators can examine the case based on the materials before them. So that would be my point to add.
One more question. I am Premsa, Chief Legal Aid Defense Counsel in Imphal West.
Yes, sir. I think we'll keep this as the last one because we have to follow Alex's instruction.
My question is very short. Is there any provision for review the earlier decisions taken by the SP in the BNS?
Review by whom?
Review by SP.
SP.
Is there any provision in the BNS? He has already decided the case is to be registered under BNS or UAP Act. Those decisions can be reviewed under what provision of BNSS?
Reviewed by the SP himself.
Yes, yes.
Good question. Can he review his own decision?
This is in the course of investigation. Everything can be changed. Everything can be changed during the course of investigation. Sometimes informant also become accused. Sometimes informant also become accused. First we start the case, then everything will be depend to the investigation. During the investigation, it happens to the having evidence of the UAP, it can be changed, but through the SP. SP has to decide again. It should be bring to the notice of the SP, because 113 says that SP has to decide. So it can be reviewed. There is no restriction in the law, but as a general law, he has to decide. First, he has to decide that it should be under the 113. Again, material come up, then again he can take decision. Because of the available evidence, this UAP will be attracted. Yes, so. Thank you, everybody. Now lunch.
Thank you, madam, and thank you, sir, for such an in-depth deliberation and analysis on the terror-related